arrest and bail provisions. Now arrest and bail provisions, let us understand, is extremely important. अपने को सबसे ज़्यादा डर किससे लगता है? जेल से। नहीं जाना भाई जेल मेरे को. We need to understand at least the basic concepts and our safeguards during these arrest bail provisions, right? Now first we need to understand what is cognizable, what is non-cognizable. These are basic terms under your criminal code. What is bailable, non-bailable? Cognizable मतलब भारी, मतलब कि कुछ बहुत बुरा आप किए, बहुत बड़ा कुछ किए, grave and serious matter, for which a police officer under criminal, not GST में police officer नहीं आता, under criminal code he does not need a warrant, आपको उठा के लेके जा सकते हैं सर. What is non-cognizable? It is not that serious, he needs a warrant. Same thing with bailable. For bailable offence, sir, थोड़ा कम, less grave it is. So what is, sir, try to understand this concept is very important. What is bail here? If in a bailable offence, which is a non-cognizable and bailable offence, what does that mean? That means that you have the right to get bail without even going to the magistrate within 24 hours of your arrest by fulfilling 4 to 5 bail conditions. First condition under GST, which we are going to see later, I have to give personal surety or bond of a particular amount. इतना का GST evasion की है 50%, या जो भी है, whatever, you know, as decided as per facts and matters of the case, as per the financial ability. First thing, give a bond. Second case, कोई local person of repute also gives a particular surety, guaranteeing this. Third, you cannot leave the country without the permission of the officer. Fourth, you have to appear in front of the investigating authority whenever you are asked to. If you satisfy all of this, this is written, signed, and you can get bail. Where you don't even have to go to the court. No, it is a right. You fulfill all of that, you give your bail surety and all that, you fulfill all this, you get bail. In which cases, bailable and non-cognizable offences. We are going to see which are those offences in GST. Second is non-bailable and cognizable. बहुत बड़ा, 5 करोड़ से ऊपर का GST का हम लोग घोटाला कर दिए. So we are going to see, you know, those and your cognizable and non-bailable offence. Means non-bailable का मतलब ये नहीं है कि आपको bail ही नहीं मिलेगा, आप सड़ते रहेंगे जेल में. No, non-bailable means you don't have an automatic right to apply for bail. You have to be mandatorily taken by the police officer or here the particular proper officer ECTC to within 24 hours to the particular judicial magistrate, and he will decide on the facts and matter of the case on several factors which we are going to discuss whether you deserve a bail or not. There are 2 options under GST law. Not in criminal procedure code. There are 3 options which are available with the judicial magistrate. First is judicial custody, मतलब jail. Second is police custody for further interrogation, and third is bail. Under GST arrest, there are 2 options. One is judicial custody, that is jail, and second is your bail. There is no police custody. Police क्या करेगा आपको रख के, right? So now under these are the basic terms under section 69 of GST Act. Let's try to understand. 4 मोटा condition है जो आप जुर्माना करोगे specified offences, जो same है, जो पहले आपने पढ़ रहे, we are going to go through that. If you do any of those offences, and if your GST evasion or your fraudulent ITC which you have claimed is more than 5 crore rupees, you can be apprehended and arrest memo can be issued if reasons to believe are there by the commissioner without even adjudication, without any recovery, right at the summons or after summons or during inspection. First what happens, inspection happens, then summon is issued, they take your evidence and immediately they can आपको उठा सकते हैं by issuing a particular arrest memo if they have clear cogent evidence that आप GST का घोटाला 5 करोड़ के ऊपर किए. So that in that case it is a non-bailable and cognizable offence. Try to understand. Non-bailable, cognizable offence. What does that mean? कि आप 5 करोड़ के ऊपर का घोटाला किए हो, ये सब 4 instances में, तो आपको जुडिशियल मैजिस्ट्रेट के सामने तो जाना ही होगा. 5 करोड़ के नीचे का घोटाला आप किए हो, all cases under GST, you can be arrested if you have done a घोटाला of 2 crores to 5 crores. 2 करोड़ के नीचे का भी घोटाला करते हैं तभी भी आपको अरेस्ट नहीं कर सकते. 2 करोड़ से 5 करोड़ का घोटाला किया अरेस्ट कर सकते हैं इमीडिएटली. 5 करोड़ के ऊपर का घोटाला किए तो कर सकते हैं इमीडिएटली अरेस्ट. लेकिन 5 करोड़ के ऊपर का करती है तो नॉन बेलेबल एंड कॉग्निजेबल ऑफेंस, मतलब जुडिशियल मैजिस्ट्रेट विल डिसाइड योर बेल. बट 5 करोड़ के नीचे का घोटाला करते हैं अप टू 2 करोड़, तो इट इज अ व्हाट इज इट? इट इज अ नॉन कॉग्निजेबल एंड बेलेबल ऑफेंस. सर 4-5 कंडीशन फुलफिल करके सीधा निकलेंगे हम लोग, राइट? दिस इज फॉर द फर्स्ट ऑफेंडर. सर आदत हो गया, वापस से सेम ऑफेंस किया हूं मैं, और एनी अदर ऑफेंस अंडर सेक्शन 132 सबसेक्शन 1. कोई अमाउंट नहीं देखना है, नो अमाउंट. यू आर गोइंग टू बी चार्ज्ड विद कॉग्निजेबल एंड नॉन बेलेबल अगर आप बार-बार सेम चीज करते हो सेकंड टाइम और मूविंग अहेड. तो ये जो फर्स्ट वाला जो मैं 5 करोड़ के ऊपर जो बोल रहा हूं, वापस लेट अस अंडरस्टैंड. 5 करोड़ के ऊपर का ऑफेंस है नॉन बेलेबल कॉग्निजेबल, मैजिस्ट्रेट से मिलेगा अपने को, 24 आवर्स में प्रेजेंट करना पड़ेगा, ही विल डिसाइड। 5 करोड़ के नीचे का घोटाला है 2 करोड़ तक, तो आई कैन विल बी अरेस्टेड, कोई प्रॉब्लम नहीं है। एडजुडिकेशन बाद में तो अरेस्ट कर सकते, उठा सकते हैं मेरे को, लेकिन बेलेबल है सर, आई विल डू दी पर्टिकुलर थिंग और मैं निकल सकता हूँ। 1 करोड़ के नीचे का है, फेक इनवॉइसिंग में कर रहा हूँ, अरेस्ट नहीं कर, 2 करोड़ के नीचे का अरेस्ट नहीं कर सकता। फर्स्ट इंस्टेंस, नॉट दी रिपीट ऑफेंडर। रिपीट ऑफेंडर में तो आपको उठा सकते हैं। 2 करोड़ के नीचे का घोटाला करते हो, किसका घोटाला है, 4 जो सिचुएशन में भी डिस्कस करूंगा। 2 करोड़ के नीचे का आप करते हो, प्रोसिक्यूशन होगा आपके अगेंस्ट। 2 करोड़ के 1 करोड़ के पीछे का प्रोसिक्यूशन होगा, लेकिन एडजुडिकेशन होने के बाद में, रिकवरी के टाइम में। 1 करोड़ के नीचे का घोटाला करते हो तो कोई प्रोसिक्यूशन नहीं होगा, छोटा घोटाला, ठीक है। तो व्हाट आर दीस 4 कंडीशन सर? मैंने 4 गलतियां ऐसा क्या की है जिसका ये 5 करोड़ 2 करोड़ का जो मैं उदाहरण दे रहा हूं। पहला गलती, एनी पर्सन हु इज अ टैक्स पेयर, और इवन इफ ही इज नॉट अ टैक्स पेयर, मैं टैक्स पेयर नहीं हूं, आई एम द किंग पिन मास्टरमाइंड, मेरा ड्राइवर है टैक्स पेयर। तो पहले लॉ में था कि सिर्फ टैक्स पेयर को पकड़ सकते हैं, मास्टरमाइंड निकल जाता था। नाउ हियर इट इज मेंशन्ड whoever commits or causes to commit, mastermind causes to commit, abet, help and retains the benefit. So taxpayer plus the person who has abetted, who has helped, both of them they can be apprehended and arrested. Under which situation? 4 है, section 132 subsection 1 clause A B C D, very important section. Section 132 subsection 1 clause A B C D, right? Clause A क्या बोलता है? सेम चीज है सर, सप्लाईज करिए, कच्चा का बिल है, बिल इशू नहीं किए, माल सेल कर दिए, टैक्स नहीं दिखाना है, टर्नओवर नहीं दिखाना है, टाली में एंट्री नहीं मारी, I have evaded tax of that particular amount of sale because I have not issued an invoice. सेकेंड केस, फेक इनवॉइसिंग, माल ही नहीं दिए, सिर्फ इनवॉइस देते जा रहे हैं, ऑपोजिट जो अपने अभी which we saw all those cases. Third case, I am the recipient, I am taking fraudulent ITC on these fake invoices, or if I am claiming input जिसका कोई invoice ही नहीं है, under rule 36. Fourth is पैसा, the supplier has taken cash, taken tax, and for 3 months he has not paid to the government. These 4 cases, there are grave cases, बहुत सीरियस माना जाता है सर इसको, और 5 करोड़ के ऊपर का तो बहुत ज्यादा ही सीरियस माना जाता है, मीन नॉन अवेलेबल एंड कॉग्निजेबल। ये 4 केस, आप अगर फेक इनवॉइसिंग करते हो, आप अगर सेल करते हो विदाउट एनी इनवॉइस, अगर आप इनपुट अवेल करते हो विच इज फ्रॉडुलेंट, और 4th केस अगर आप गवर्नमेंट का पैसा मार करके बैठे हो 3 महीना से ऊपर, तो इन एनी ऑफ दीज 4 केसेस अंडर सेक्शन 132 सबसेक्शन 1 क्लॉज A B C D, 5 करोड़ के ऊपर का अगर है तो इट कम्स एज क्लॉज 1 अंडर सबसेक्शन 1 ऑफ सेक्शन 132. सेकंड, 2 करोड़ से 5 करोड़ क्लॉज 2 एंड सबसेक्शन 2 होता है रिपीट ऑफेंडर. ये 3 केसेस, रिपीट ऑफेंडर एनी अमाउंट, 5 करोड़ के ऊपर वाला आदमी और 2 करोड़ से 5 करोड़ वाला आदमी अरेस्ट हो सकता है इन एनी ऑफ दीज 4 केसेस. सर 180 दिन तक पेमेंट नहीं किया सप्लायर को, अरेस्ट कर देंगे? नो, ही कैन नॉट, बिकॉज इट इज नॉट कवर्ड अंडर 132. सर 2A 3B का डिफरेंस है, सर अरेस्ट कर सकते हैं? नो, ही कैन चार्ज अ पेनल्टी ऑन यू. अरे सर 1 करोड़ के नीचे का भी तो फेक इनवॉइसिंग करे तो अरेस्ट भी नहीं कर सकते, उसमें प्रोसिक्यूशन भी नहीं कर सकते. 2 करोड़ के नीचे का भी घोटाला आप करते हो तभी भी अरेस्ट उस टाइम नहीं कर सकते हो, प्रोसिक्यूशन होएगा एडजुडिकेशन के टाइम में. दीज आर द सेफगार्ड्स व्हिच वी नीड टू अंडरस्टैंड. नाउ रीजन टू बिलीव, जैसे मैं बोला कि देयर शुड बी अ प्रॉपर एविडेंस, देयर शुड बी it should not be subjective, it should be objective, there should be proper evidence, it should not be on surmises, conjectures, gossips, वो सब चीज नहीं चलेगा. Proper written evidence in your file with the investigation, all of those summons and all of those statements. एक मोटा कुत्ता होना चाहिए आपका लिखा हुआ कमिश्नर के पास में. Then सब लीगल ग्राउंड्स देखना चाहिए उसको. सेक्शन 132 का ग्राउंड कवर्ड है? यस कवर्ड है. सेक्शन 69 में हैज ही ऑथराइज्ड एनी ऑफिसर? यस, प्रॉपर्ली इट्स कवर्ड. So all of those things are required. So here there are the Tata Chemical here Supreme Court judgment where it is mentioned that it cannot be a rumor, suspicion. It needs to be proper evidence, right? Now, sir, ये arrest memo क्या होता है? हम लोगों को नहीं पता है, तो सिर्फ भाषण आप दे रहे हो. Arrest memo, I will show what is an arrest memo. It has to be prescribed in a particular format. Sir, arrest memo में सब evidence दे दे क्या उसको? हम उसको पकड़ने जा रहे हैं, हम बोलेंगे सर मेरे पास में 100 पेज का evidence है which I have assimilated from all my investigation for the last 6 months. Am I duty bound as a commissioner or any authorized officer under commissioner to give that entire gutta of evidence at the time of arrest? No, I will just explain the basic ground of arrest, the section which is invoked. Section 132 subsection 1 clause A में आपको पकड़ रही है, B में पकड़ रही है, C में पकड़ रही है, D में पकड़ रही है, और basic ground which I am going to mention in the arrest memo which we are going to see. So there is a particular case law also which is in PV Ramana Reddy, Telangana High Court. It is mentioned it is enough to have reasons written in a file then to show it and explain everything in detail or give it to the person arrested. No, it is not required. Magistrate को दीजिए ना आप 24 घंटा बाद में, बेल नहीं देना इसको. प्रोसिक्यूशन चार्जशीट फाइल करना है, चार्जशीट नहीं होता, प्राइवेट कंप्लेंट, प्रोसिक्यूशन कंप्लेंट 60 डेज में फाइल करना है, तो वहां पर यूज करो आप. अरेस्ट के टाइम में उसको इतना भाषणबाजी नहीं देने का है. वी डोंट हैव टू. Right now, reason to believe, as I said, it is not necessary to communicate the same in writing to the person arrested. Right? There are divergent case laws also, but this is the settled law. Now, same must be written in writing in files at least. आप उसको बोलोगे नहीं, दोगे नहीं, लेकिन फाइल में होना चाहिए आपको. It should not be, the reasons to believe should not be based on opinion. We've discussed all of this, right? Credible material होना चाहिए. There should be grounds which are mentioned, right? Now, guidelines. All this is law. Lekin to regulate it, where are the SOPs? These are the guidelines issued by the CBIC for arrest. Sir, very important. They are saying to the commissioner, sir, legally सब आप fulfill कर लिए हो. Round है, हाँ. 5 करोड़ का evasion किया, हाँ. 2 करोड़ का evasion किया, हाँ. 2.5 करोड़ का किया, हाँ. ठीक है. ये चारों ground है, हाँ. ठीक है. Authorize आप किए हो 69 में proper officer को, ठीक है. All of those things are fine. Legal obligations are be fulfilled, but whether there is a necessity to catch that person, to arrest that person. Sir, arresting shatters our self-confidence. It is against our freedom, against a constitutional right to freedom. So arresting someone is a very big deal. So do you feel that it is necessary to arrest him? Necessary का मतलब क्या हुआ? If I don't arrest him, will he go and will he tamper with the evidence during the investigation? Whether he will intimidate the witnesses, whether he will disrupt the investigation procedure, whether he will actually be available for summons कि भाग जाएगा, whether it is a cognizable or a non-bailable offence, 5 करोड़ के ऊपर का है क्या नहीं है, whether it is a benami transaction, whether he is the kingpin, whether he is a repeat offender, all of these factors are seen. And with legal obligation fulfilled, section 69 read with section 132 plus necessity as per these particular guidelines factors, all of that, then you issue an arrest memo, you authorize a junior officer and he goes and he picks him up. If the case involves any offence, specified offence under section 132 subsection 1 clause A, B, C, D, and the offence tentative offending, the offence, the amount should be more than 2 crores, 2 to 5 crores or more than 5 crores. Then you can be arrested without adjudication also. ये सब जो मैं बोला हूँ, these are very important. Also, mens rea we word, guilty mind होना चाहिए. मैं भूल से कर दिया, मेरा कोई evasion नहीं है, कोई fraudulent activity नहीं है, भूल से हो गया. अरे सर adjudicate करो ना, arrest क्यों कर रहे हो सर अब उसको? भूल से हो गया सर उसका. You need to see that he has planned it. He has a guilty mind. There is mens rea, so you need to see that. Sir, कौन से केस में arrest नहीं कर सकते हैं? Classification issue. If there is any classification issue, it is not fraudulent. I have not done fake invoicing. It is a classification issue. मेरा इंडस्ट्री में ये prevalent है. I am doing this. मेरे को law, interpretation of law. Those cases don't do arrest, do adjudication. Secondly, I am very cooperative. Summons attended, no evasive reply, given all replies, furnished all documents. I have attended to all summons, given all everything. So in that case, he may not be arrested. Sir, what is the difference between normal murder theft case, criminal in criminal code, and GST arrest? First case, no FIR. In GST there is no FIR. In criminal code there is FIR. यहाँ पर FIR क्या होता है? अरे reasons to be recorded in writing. The commissioner will record the reasons, evidences, and will authorize the junior officer to arrest that person by issuing an arrest memo after all the fulfillment of legal obligation, necessity, everything. That is it. No FIR. Right. Second thing, as I said, there are 3 outcomes in front of the judicial magistrate. First is jail, judicial custody, police custody, and bail for your normal criminal code. In GST, no police custody. Police क्या करेगा? What will police do? There is either jail or you are on bail. Third thing, charge sheet. Sir, within 60 days in criminal code also you have to issue a charge sheet. उसमें सब चीज आपका investigation, सब चीज जो भी violations, all the things which you are implicating the person, you have to mention within 60 days. In GST there is nothing called charge sheet. Private complaint, prosecution complaint. If the person has not got bail, denied bail, then you have to, he cannot be in the jail for more than 60 days. There is default bail. 61st day he will be out. Default bail if you have not filed your prosecution complaint within 60 days, right? So these are few different this thing. Arresting procedure, sir, very important. We are going to see this particular format. Sir, arresting procedure, we are going to, what is arrest memo? What is an arrest memo? In that arrest memo we don't have to mention all the evidence. You just need to mention the basic ground under which we are arresting him and invoke the section 732 subsection 1 A, B, C, D. We need to mention the date and time. We need to mention the fact that he has exercised his right under GST also and criminal code also. What right? To inform his family member, friend, one person he can call and inform, sir, I am being arrested, please come and save me. He has that right. And that right, whether it has been explained to that person and whether he has exercised it, it needs to be mentioned in the arrest memo. Yes. Whether the grounds of arrest have been explained to the particular person arrested. Yes. Tick. Jama talashi. Pocket mein mobile phone hai, ye hai, etc. I will write in a piece of paper in front of a witness. I will seal it. I will take the signature of the witnesses. All of those details are to be mentioned here. There is a particular, as I mentioned, instruction 02/2022-23. It mentions arrest memo. It has to be a prescribed format. Din hona chahiye, sir. इसमें भी din नहीं होएगा तो you cannot be arrested. You can challenge it, but they will immediately issue another arrest memo and they will apprehend you. They will let you free. But it needs to be a prescribed format as per this particular circular. Din needs to be there. The copy needs to be a particular copy of arrest memo needs to be handed over to the person arrested. Right. Now this is, I'm not sure if you guys can see this thing, but when you get the deck out here, you will see there is no place to write the entire full grounds of defenses. Sorry, grounds of arrest. You just need to mention the section and brief ground of arrest. Sir, आपका ये सप्लायर था, ये चोरी किया था, या तो आप टैक्स 3 महीना से ज्यादा पेमेंट नहीं किए, या तो आप फ्रॉडुलेंट आईटीसी लिए हो, या तो आपने इनवॉइसेस इशू किया फेक इनवॉइसेस, या तो आपने कच्चा का माल बेच रही है, उसका बिल ही नहीं कर रही है, राइट? वो समझाना पड़ेगा थोड़ा सा, बहुत ज्यादा कुछ नहीं, फुल एविडेंस वी कैन नॉट गिव, राइट? सो दिस इज द पर्टिकुलर फॉर्मेट व्हिच नीड्स टू बी एंटिसिपेटरी बिल. सर, आई नो आई मे हैव डन अ डिफॉल्ट ऑफ मोर देन 5 crore rupees. भूल से, गलती से, फ्रॉडुलेंटली, कि मेरा सप्लायर एक्सेट्रा जो भी है, ऑल दीज केसेस, एनी ऑफ दीज 4 cases which I mentioned, and the amount is more than 5 crores, I am called for summons 2 days later. Can I file for an anticipatory bail? Anticipatory bail means that before they arrest me, I have a particular bail which I can show and I can be free. So there are divergent case laws here. Before the initiation of any inquiry in summon proceedings, can you get an anticipatory bail? Yes, you may not. But you have to give some pre-deposit. You cannot just anticipate a particular anticipatory bail without giving a pre-deposit. But it depends on the facts and circumstances. Regular bail, sir, what is regular bail? Sir, I have done a cognizable non-bailable offence. 5 crore के ऊपर का घोटाला मैंने किया है. Out of these 4 things which I mentioned, fake invoicing, and I have not issued the particular, मतलब कि I have not supplied the goods. 3 महीना से गवर्नमेंट का पैसा लेके बैठा हुआ, और I have claimed input tax credit which is fraudulently. These 4 cases. So the more than 5 crores. So at that particular point in time, what happens? I am arrested and I am presented before the magistrate. No automatic bail that I will apply and I will get 24 hours and he will decide. That is regular bail. So the particular judge, magistrate, he will see these particular factors which we've already discussed. Sir, gravity of offence, cognizable है कि non cognizable है, repeat offender है क्या, प्री डिपॉजिट किया है क्या, सर इन्वेस्टिगेशन छोड़ दिए तो इन्वेस्टिगेशन में बाधा डालेगा क्या, टैंपर करेगा एविडेंस, कैन ही इंटिमिडेट पीपल, और what is or the evidences which the department has, whether it is frivolous, right? All of those things will be seen, and a bail can be granted or he can be sent to jail. Default bail, as I mentioned, what is default bail? So no charge sheet has been filed after arrest, bail नहीं हुआ, after arrest for 60 days. Department is saying इसको रहने दो ना जेल में, क्या है? No, for 60 days you cannot stay more in the jail, more than 60 days. If a charge sheet or a private complaint, prosecution complaint has not been filed, you cannot take the liberty away from the person of freedom. 61st day tak he will be default bail. So this particular case, many times we see this also, that a person is out on default bail. Now there are certain case laws. This is the last part, just 2 minutes I will take. There are certain case laws which are favorable, which mention that, sir, adjudication proceeding करिए, show cause notice issue करिए, demand आप issue करिए, demand order लाइए, recovery proceeding करिए, फिर prosecution करिए. You cannot arrest a person before adjudication. How can you find him to be, he's accused, he's not guilty? First do adjudication, find him to be guilty, then you can prosecute. So there are many pre-GST and post-GST case laws also. Make my trip, where Supreme Court had judged this, it had upheld this, that you cannot arrest a person until and unless adjudication is done, until his charges are framed, until his prosecution then happens later. There are few case laws which are mentioned here, but sir, we know section 132 subsection 1, it is the proper legislative, right, legislation. So that read with your section 69, right? So these sections, if you have committed वो 4 जो मतलब कि जो grave offence which I have mentioned, first is clause A is that you are not supplying the goods, basically, sorry, you are supplying the goods without an invoice. Second is you are issuing invoices without any supply of goods. Third is you have claimed input on such fraudulent invoices. And fourth is 3 महीना से आप गवर्नमेंट का पैसा पेमेंट नहीं किए हो. 5 करोड़ के ऊपर नॉन बेलेबल कॉग्निजेबल, 2 करोड़ से 5 करोड़. So it is, you can still be arrested, but it is non-cognizable and bailable, right? 2 करोड़ के नीचे you cannot be arrested right now. 1 करोड़ के नीचे prosecution ही नहीं होएगा बाद में, right? So those particular cases here, this particular PV Ramana Reddy in this Telangana High Court, they mentioned that sir वो सब बात छोड़ दीजिए. Section if 5 करोड़ के ऊपर का आप गलती करते हो, 2 करोड़ के ऊपर का 132 में आप कोई भी grounds आप specified offence करते हो, you will be arrested sir before trial. You will be arrested before show cause notice is issued. And you have to follow the code of law, right? Also in Vimal Yashwant Giri Goswami, there's a Gujarat High Court judgment. Same thing this is mentioned, that before adjudication proceeding, before issue of show cause notice, you can be arrested by issuing an arrest memo with reasons to believe in these